Mr. Speaker. Mr. Speaker, I just want to begin with a quote. This is from Dave Pelsner. Childhood should be carefree, playing in the sun, not living a nightmare in the darkness of the soul. Mr. Speaker, I want to make a couple comments, and I want to thank Representative Marsico, Chairman Marsico, and Chairman Petrarca for bringing this bill forward. Just a little bit of background about the statute of limitations. We know what the statute of limitations is and why it exists. This population of victims of child sex abuse is a very special population. It's a wounded population, a population that's hiding in shame, humiliation, and silence. And sometimes there's a question about whether or not a window or retroactivity on civil claims is constitutional. And as my colleague from Berks County articulated very well, retroactivity in the civil sense is absolutely constitutional. As manifested in 1994 in the Landgraf versus the USI film production case, and in 2003 in the Stogner versus California case. But Mr. Speaker, there exist 3 grand jury reports that have come to light in the Commonwealth of Pennsylvania. And I just want to read a couple excerpts, if I could. From 2003, the Philadelphia District Attorney issued a grand jury report that I have right here. No, I'm not going to read all of it. I heard that. But I do want to read an excerpt, Mr. Speaker. Unfortunately, the law currently stands in the way of justice for the victims of childhood sexual abuse. Although we have a wealth of evidence against many of the abusers, including their own admissions, and in many cases, the Archdiocesan Review Board's own determination that the charges against the priest are credible. That's the Archdiocese of Philadelphia. We cannot indict any priest who abused a child for any of the crimes of which we are currently aware because the relevant statutes of limitations have expired for every single act of abuse known to us. Offending priests are therefore immune from prosecution for all the crimes detailed in this report. All, and I apologize for this verbiage, all of the anal, oral, and vaginal rapes, all the fondlings, all the caressings, all the unwanted, inappropriate touchings and undressings they perpetrated upon archdiocesan children. Nothing changes this result, not the severity of the sexual assault, the degree of force or psychological coercion, or the age of the victim at the time of the abuse. Under present Pennsylvania law, the single fact is the date of the final act of abuse, and we do not know of any act of priest-child sex abuse recent enough to permit prosecution in the Commonwealth under the current statute of limitations. Pennsylvania's statute of limitations for sexual crimes have been revised numerous times since 1982. The most recent amendment, as of 2002, requires child sex abuse cases to be initiated by the date of the child victim's 30th birthday. The experts have told us that this statute is still too short. We ourselves have seen that many victims do not come forward until deep into their 30s, 40s, or even later. And I remind you about our distinguished colleague, Louise Bishop from Philadelphia, who came forward when she was in her 70s. She was raped when she was 12 years old in Georgia, in the Old South, before World War II. Moreover, even the 2002 amendment cannot be applied to the cases we have seen because changes that lengthen the limitations period cannot be reused to revive criminal prosecutions that were already barred under the original deadline, as the United States Supreme Court has recently made clear in Stogner versus California. Even a former official of the Archdiocese has recognized the need for this proposal. Edward Cullen, who was Cardinal Bevilacqua's vicar of administration and who has since himself been elevated to bishop, was asked about the issue during his grand jury testimony. Bishop Cullen responded, and I quote, "I think it would be good for society if they had no statute of limitations," acknowledged Bishop Cullen. I really do. Yes, I do. The last thing from this grand jury report in 2003, Mr. Speaker, is recommendation number 7. We recognize the reality that civil liability may also provide a disincentive to the kind of systematic sexual abuse that occurred here. Indeed, archdiocesan officials never seemed to believe that clergymen could ever go to jail for abusing or allowing the abuse of children. But they did display an obvious fear that they would be sued for such conduct. For many victims of sexual abuse by priests, civil liability may be the only available means to seek recognition of the injuries and a measure of repose. Moreover, unlike statute of limitation for criminal offenses, the time for bringing a civil suit can be lawfully extended or revived even after the original limitations period has expired. Accordingly, we asked the legislature to consider lengthening them or suspending civil statutes of limitations of child sex abuse. That's from 2003, Mr. Speaker. 2008, the Philadelphia District Attorney issued another grand jury report. And I'm only going to read the recommendation. And this is number 1. First recommendation: enact a 2-year window to allow child sex abuse victims to have their cases heard. We recommend that the Pennsylvania legislature suspend for 2 years the civil statute of limitations on child sex abuse claims. Such a window of opportunity, appropriately limited to 2 years, would allow adults who were victims of sexual crimes as children to have their cases heard in a court of law. The statute of limitations in force when many of these victims were abused required that any civil litigation begin within 2 years of the time of the abuse. Thus, a 10-year-old rape victim had until he was 12 years old to file suit against his abuser. It's well established that most victims of childhood sexual abuse do not come forward with allegations for many years or even decades after they were molested or raped. For this reason, the civil statute of limitations of recent years has been extended. However, as a result of the law's past inadequacy, sexual predators who prey on children continue to be shielded from exposure. The vast majority of complaints received by the Philadelphia Archdiocese Victim Assistance Program, in fact, have fallen beyond the statute of limitations. Without a window in which their cases can be heard, victims must depend on the archdiocesan hierarchy's willingness to validate their allegations, acknowledge their suffering, and compensate them for expenses incurred, such as psychological counseling or drug treatment. A 2-year window in the statute of limitations might offer the best hope these victims have of finding a measure of justice. More than that, the possibility of civil liability would increase church officials' incentive to make meaningful reforms and institutionalize intolerance of child sexual abuse. The grand jury report from Altoona and Johnstown, Mr. Speaker, I'll only read the recommendation. Open a window to allow child sexual abuse victims to have their civil actions heard. The grand jury recommends that the Pennsylvania legislature suspend the civil statute of limitations on sexual abuse claims for a designated and finite period of time. This relief would allow adults who were victims of child sexual abuse to have their cases heard in a court of law. The statute of limitations, in effect, leaves insufficient time to seek relief for crimes that are inherently underreported or are delayed in reporting. The grand jury took testimony and reviewed evidence which showed many of the child sex abuse victims who sought relief from the Allegation Review Board alleged conduct which was beyond the civil state of the statute of limitations. The lives of child abuse victims are permanently altered by their assaults. They deserve to be made whole. Someone called child sex abuse murder of a child's soul. Organizations which have a history of secrecy in regard to child abuse allegations will consider meaningful reform when their failures have financial cost. Victims deserve the opportunity to seek full and fair settlement, not, as one church official stated, settle for what they get. Mr. Speaker, these amendments relative to retroactivity still require a victim of child sex abuse to prove their victimization, to prove their case or cases. Much of the proof exists sitting in church archives someplace in the form of memoranda, email, incident reports, interview reports, and so forth. Mr. Speaker, some people are curious whether or not window legislation has been the status quo in other states, and the answer is affirmative. 8 states have already enacted window legislation. California, with a population of 35.25 million people, enacted a 1-year window. Guess how many people filed claims? 1,100. Delaware, population of 935,000. 175 people filed claims. Minnesota, population 5.5 million. 44 plus 419 people filed claims. Hawaii, population 1.42 million. 125 claims have been filed. Last thing I want to say, Mr. Speaker, this issue, I resent anyone saying that this issue is being driven by special interests, by trial lawyers. This issue is being driven by victims, some of whom are sitting up in the gallery, some who have suffered, as I said before, in silence and in humiliation and in shame. As I said before, the shame is not theirs. The shame is ours if we do not take action on this issue to help these victims and to prevent the victimization of any other children. One of the worst things that has come out of some of these grand jury reports is the fact that the Archdiocese of Philadelphia, or the Diocese of Altoona and Johnstown, actually knew that many priests were child molesters. They were worse than pedophiles, they were child molesters. They knew it, and instead of taking action, they sent the priest on retreat. They moved him to another parish. Sometimes they offered a cash settlement to the victims. Despicable behaviors. The amendments that I have on this bill, I believe, are in order. I believe they would provide a measure of justice, not complete justice, but a measure of justice to our victims. But I'm going to withdraw both amendments that I have on this bill at this time in order for the Marsico and the Petrarca bill to move quickly from the House in the hope that our colleagues in the Senate will provide some measure of retroactivity. Thank you, Mr. Speaker.